Okay, Assalamu alaikum wa rahmatullah wa barakatuh. Welcome to today's lecture, which is set up and organized by the Library Lecture Series programs. We are fortunate to have Dr. Dawood Hamzah again. The first time he came was last May, almost speaking about the same subject, but now since he published his book, which is a study in comparative law, civil law, Islamic law, and common law, which was published last year. It consists of 2 volumes. So Dr. Dawood, he will be covering, going over the chapters, but in brief manner. He's a former lecturer at SOAS College, University of London, and he has other qualifications in the field. His PhD in particular is in relation to international law and Islamic law, and interaction of 2 legal regimes, which he has achieved in 2015. Without further ado, I'm going to introduce Dr. Dawood and ask him to begin his lecture. Thank you.
أعوذ بالله السميع العليم من الشيطان الرجيم بسم الله الرحمن الرحيم اللهم علمنا ما ينفعنا وأنفعنا بما علمتنا وزدنا علما اهدنا الصراط المستقيم اهدنا الصراط المستقيم اهدنا الصراط المستقيم صراط الذين أنعمت عليهم من النبيين والصديقين والشهداء والصالحين وحسن أولئك رفيقا اللهم صل على عبدك ورسولك محمد وعلى آله وصحبه أجمعين. I thank you very much as we are gathered today here. I know that the time has constricted and I have to be very, very economical in spending the time. But despite that, I must observe 1 or 2 points before I start. Number 1, I understand that many people online, and then they have been waiting because the time is supposed to be 5 o'clock. But because of circumstances beyond our control, we could not start at 5 o'clock exactly. We are sorry about that. Secondly, I would like to acknowledge some personality and some institutions that they provide a kind of inspiration to this work. Number 1, I want to appreciate Dr. Ahmad Dubian, the head of this institution, that is Islamic Cultural Center, and all the member of trustee of this center. Also, I want to appreciate Brother Sayyad Waris of the library here, and as well as Brother Ayaz Zubair, and Professor Roberto Scaglia of University of Trieste, Italy, and Professor Mark van Falk of the Queen Mary University, London here, and Professor Masoud Badeni of SOAS, as well as the Sheikh, Dr. Imran Alawiye, then Professor Kasim Mamadou Kasim of Crescent University, Abeokuta in Nigeria, Professor Abdul Karim Olatoye of Lagos State University, Nigeria, Professor Ishaq Oloyede, former Vice Chancellor of University of Ilorin, and presently the Registrar of Joint Admission and Matriculation Board in Nigeria, and then Professor Abdul Wahab Egbewole, the current Vice Chancellor of University of Ilorin, and also Professor Dr. Moiz Banire. Among institutions I want to recognize is Muslim Association of Nigeria UK branch, Man UK, based in Oak Kent Road, London area. Also, I want to recognize the Markaz Islamic Cultural Center under the leadership of the Man UK and under the leadership of Dr. Musa Abdul Rahim. Also, among them is Jamaat Islamiyah of Islamic Center in Camberwell, Southeast London, and of course, Organization of Muslim Unity in Nigeria and the Companion also in Nigeria. All these respected individuals and institutions, they provided inspiration in this particular endeavor. Now, because of time, let me quickly go to the work. I want to start by talking about the structure of the book. We have seen the title, A Study in Comparative Law, Civil Law, Islamic Law, and Common Law. The structure of the book is such that it's divided into 2 volumes, consisting of 8 chapters in all. Volume 1 examines the historical trajectory of comparative law. Volume 2 examines the principles and methodologies of comparative law under both the 2 legal regimes, so the Western conventional law and Islamic law. Now, there is a kind of expert touch. This will give me opportunity to recognize the assistance provided by Professor Roberto Scaglia, who was a former professor of comparative law at University of Trieste in Italy, and then who wrote the foreword to Volume 1, and of course Professor Mark Van Hoek is a professor of comparative law at Queen Mary University, London here. Now, there is need for me to make some clarifications, because it may come to the mind of some people that, are you comparing the law, the man-made law, with the law of Allah? So I said a study in comparative law is about exploring the principle, structure, and methodology used to examine and compare legal system across different jurisdictions. It is an attempt to interrogate how major traditions, civil law, Islamic law, common law, approach similar legal challenges, revealing both their shared values and distinctive peculiarities. So it also examines the historical development of this system, investigate the influence of culture and politics in the heart of lawmaking. So it also offers a foundation for understanding cross-border legal dynamics, fostering dialogue among the diverse legal culture, and guiding reform through comparative vision. This book is not about an attempt to compare human-made law with the law of Allah as embodied in the Quran and Sunnah of Prophet Muhammad sallallahu alaihi wasallam. It does not judge or rank legal system, neither does it seek to determine whether a law or legal system is better, worse, more advanced, or more primitive than the other. Its purpose is understanding, not evaluations, competition, or claim of superiority. It does not attempt to import or impose Western legal categories onto Islamic law or Islamic law concept onto Western system. Of course, a sound comparative approach does not assume that Western ideas such as strict church-state separation or legal positivism are universal benchmarks. We are going to see that later in the course of these explanations. Accordingly, this study avoids distorting Islamic law by forcing it into analytical frameworks or legal positivism, which are universal benchmark. Accordingly, this study avoids distorting Islamic law by forcing into analytical framework foreign to its intellectual and moral foundations. this book is not a political or ideological project. It does not aim to justify colonial legal reform or delegitimize Islamic legal tradition or promote or oppose Islamization agendas. It is not about uniformity or harmonizations. It does not seek to make Islamic law conform to international or Western legal norms. Rather, it examines differences, similarities, and the underlying logic of distinct legal system. So, in that case, what is the comparative law? What is it all about? I'm talking from the conventional point of view. Methodological approach to investigate law of different legal culture to come up with a sound framework for a better understanding of the role of law in those cultures. We can see this particular position in the book of Edward J.B. Then it is, the comparative law is not a legal text or body of rules. It is more of a methodology of analyzing different fashions of the law. The first mention of comparative law as a legal term dates back to the 17th century, then in an English, by an English author. His name is Bacon. It was quoted, it was reported that he said he was the first person to make reference to that particular term, comparative law. I'm talking the perspective of Western conventional legal system. Then, from Islamic point of view, what is comparative law in Islamic perspective? It is the systematic study and comparison of different legal rulings, ahkam, across Islamic school of law, madhahib, and sometimes between Islamic law and other legal system. This particular point, comparing Islamic law with other legal system, is a development that came out, and we are going to see the first scholar of Islam that first of all attempted to do comparative system of Islamic law with conventional law. So those are the two main broad lines of comparative law according to Islamic law. We are going to see that immediately after the demise of Prophet Muhammad sallallahu alaihi wasallam, the Sahaba started to have issues cropping up, and they need to attend to address those issues. So opinion started to differ. Of course, when Prophet Muhammad sallallahu alaihi wasallam was alive, people used to have different opinion on particular issues, but because of his presence, is the final arbiter that will resolve such issue. So, number two, how rulings are derived, that is istinbatul ahkam, from the primary and secondary sources, that is Quran and Sunnah, and the secondary sources like ijma, qiyas, and other principles. So it is also about highlighting area of agreement, ijma, and legitimate disagreement. That is al-ikhtilaf al-ilmi al-mu'tabar. إذا كان سياق فقهيا أو شرعيا. To deepen understanding, promote legal flexibility, and support sound ijtihad in changing context. A method classified into two broad outlines, as I've said before: comparison of a substantive issue among different schools of Islamic law, and comparison of specific subject of Islamic law with other non-Islamic conventional law. Now, I started with the first chapter because when you talk of law and society, there is need for us to know what is the function of law in the society. So, law in the society is an examination of a shared symbiotic relationship between law and society. Each impacts and shape the other in continual dance of influence. And then I look at some society, their legal system, including Egyptian law. When I say Egyptian law, I'm talking of Egyptian law before Islam, before the advent of Islam, the Greek law, Indian law, Chinese law, law in Europe, particularly civil and common law. We are going to see that the influence of civil law on common law, of course, because of historical reason. And then African law and the sources. We remember following the colonizations of African countries, we have many principles. For example, the repugnancy principle, we are going to see that as well. Then Islamic law. Islamic law, you know, because of the fundamental of Islam, so Islamic law is applicable in anywhere you see the Muslim. Now, the chapter 2 of that volume 1 is a kind of comparative historical trajectory. So, first of all, we have to note when we talk of comparative study, you know, because it is championed by the Western jurists, Western scholars, so it is noted that Eurocentrism constitutes a critical challenge to comparative legal history and has seemingly eclipsed theoretical and methodological perspective by eroding the entire geographic region's legal experiences. As I said, the effect of colonialism, when the colonial master arrived in many African countries, so they will introduce what we call repugnancy tests. A particular law is subjected to this test, and then they will say this particular law are barbaric, and so it has to be expunged. So, in other words, this particular position can be considered as Eurocentrism. So, this argument, you can find it from Chinese scholars. You remember that even Britain has colonized China at a century. So, they view their law from the perspective of the Western system. And you see, if you go to the issue of China, you see these traces of a common law. So the common law is the applicable law in Britain, and all their the territory they colonized. So they introduced the law of Britain, and that is why any law that they met at the particular place, they will look at that law from their own perspective. Now, there is no time for me to go to details of chronology of comparative law. As I said, it started particularly the first, if you look at the name of a gentleman, Gottfried Wilhelm, I think it's a German. So it was the first person to introduce the idea of classifying legal system into several families in 1667. So then modern comparative law started particularly in the 19th century. And I want to recall, particularly in 1900, the first International Congress of Comparative Law was held in Paris. In these particular occasions, so scholars were gathered to specify the nature, aims, and general interests of comparative law. That is when comparative law becomes formally a discipline. Before then, comparative law is just a matter of talking about it. So, and then I have, according to Professor Skajia, that I mentioned his name now, he identified 7 or 8 phases of comparative law. The ancient world, when the 12th tablet was the popular law in Italy in the classical period of Romans, the Middle Ages, the Renaissance, the 17th and 18th centuries, and then the 19th century, the part which I mentioned now, and then the second half of 20th century, and of course, the 21st century of globalization and global village. So, then comparative law we have to ask ourselves, what is the position now? Scholars maintain different positions on what is the position of comparative law in this 21st century because of globalization. You know, globalization has turned the entire universe to a global village. Of course, in the book, I try to look at many places where Allah mentions Al-Qura. For instance, Allah mentioned Mecca as Qura. Qura, several places in Quran where Allah recognizes that. And of course, the scientists have come to tell us that Mecca is the central epicenter of the heart. Then why Allah mentioned Mecca as Qura, and of course we have University of Qura in Mecca. So from that particular point, the issue of global village has been recognized in the Quran before a gentleman in the 1960s. It was, I think it's a Canadian journalist, who would now talk about global village, because at that time, the printing system has become spread. It was, during that time, we have television, television, all those analog television, the phone, all this kind of communication system. So he then thought about the world now is turning a global village. That is in 1960. Of course, in the book I said, no, globalization is not new to Islam. If you look at many verses in the Old Quran, Allah mentioned, لِيُنذِرَ هُمُّ الْقُرَى وَمَنْ أَوْلَهَا. So the Qura, that is mother of the villages. So Allah used Jamu, that is plural. Al-Qura is Jamu. So in other words, Mecca is the mother of the villages. So the issue of globalization, as far as Islam is concerned, is not a new thing. Then I talk about 21st century. What is the position of comparative law? So according to an opinion, significance of comparative law in the traditional sense has been decreasing and potentially coming to an end. And of course, this argument can be valid in view of the international media. International media now, we can see what is going on somewhere. If there is any development of law in somewhere, you can just click your phone and get information about it. So now, the comparative law assumes the status of Cinderella of legal studies, that it has come to a peripheral level and diminishing importance in legal education. Then, finally, a presumption of an evolving nature of comparative law, despite changes in the global legal landscape, and will never cease to exist due to constantly evolving characteristics. This argument is also valid because we are living now in a situation that no country can say that is independent of other countries, or no society can say, I am independent of another society. And in the interaction between each community, there are bound to be class of interest, and then how do we settle those interests? We have to go to law. So comparative Islamic law, a historical trajectory. As I told you, you see, Islamic comparative law has started. Immediately we started to have, just during the period of Sahar, the first Radil Caliph, Abu Bakr, Omar, Ali, Uthman, radiallahu anhu jamia. During their period, people started to, issues started to arise. And they have to refer to the Quran to determine the position of Islam on those issues. So after that, and as I said, even during the period of when Prophet Muhammad ﷺ was around, so there are few that people disagree on issue, but it is the Prophet himself that will be the final arbiter. I have no time to mention several instances of that. So, but now the Prophet is no longer around. The Khulafa Rashidin have gone. The Tabi'ina are now in the fog. What do? So they look at issues. And in the process of this, they disagreed on issues. So when they disagreed on issue, they now try to know the position of one scholar and another position of another scholar. This was what is led to the emergence of the School of Islamic Law, Madha'ib. We have the Maliki, based in Medina. Then Shafi'i, I think based in Basra, in the jurisdiction of Basra and Kufa, and Egypt. And then you have Shafi'i and Imam Ambali. So all of this is what led to the emergence of all these scholars. They started to look at the Quran and the Sunnah from the mechanism of ijtihad. They look at tafsir of the Quran, ayatul Quran. How do you understand this ayah? They interpret ayatul Quran in the light of the Sunnah, and they come out with a particular hukum. So this is what led to the fiqh muqarin. Fiqh muqarin is essentially a development that started along with the methodology of Islamic law itself. So in the Western world will say Islamic law, but there is nothing like Islamic law. Islamic law, Quran and Sunnah are the sources. Fiqh is the methodology. Methodology is how the law was derived from the Quran and Sunnah. So that is a methodology in a general sense. But when you talk about, and then this methodology is the way the fuqaha, the scholars, the way they interpret the ayat of Quran and Sunnah of Prophet Muhammad sallallahu alaihi wasallam. How do they apply it? How they understand all those sources of Islamic law? So the methodology of Islamic law is the fiqh, so known as jurisprudence. So now you can see now that fiqh muqarran started exactly when the scholars started to come out with ahkam from those main two sources. So I say it is synonymous with Islamic jurisprudence itself, as both of them developed contemporaneously. It is critical for understanding the diverse legal and ethical interpretation within the Muslim world. It later developed to compare the Islamic legal principle and concept with non-Islamic legal rules. It is when after the period of Khulafa, the Tabi'in, they sparse to various parts of the world. So they started to have contact with different cultures, like many countries in Asia. So this is where the ideal of compare the principle of Islamic law with the existing law in the particular jurisdictions. So thus, the issue of Islamic jurisprudence and Islamic comparative jurisprudence overlap and share some historical affinity. You can see from what I've said so far that in the case of Western conventional law, it was a kind of official, a kind of practical step taken to introduce the fiqh muqarran, that is comparative law. But in the case of Islamic law, it is natural, right from the people started to look at issue on different perspective. So people now started to look, what is the position of Imam Malik on this particular issue? What is the position of Imam Ambali on this particular issue? So they now compare. So when they compare, then they give you leverage to follow anyone that you feel that is appealing to you. Of course, all of them, they have to base their ahkam on the Quran and Sunnah. So comparative chronology of comparative Islamic law, I identify 5 phases. The formative phase, which mark the beginning of the mission of Prophet Muhammad sallallahu alaihi wasallam. The second one, the era of companion, when the Islamic jurisprudence had crystallized into a clear legal form. Then number 3, the era of the Tabi'in. So Islamic jurisdiction had expanded beyond Arabian Peninsula. Then number 4, this is the modern time when comparative jurisprudence has taken a new trend. Here, efforts are being made to achieve a balance devoid of dogmatism for particular imam or school. At a point, people became dogmatic about those school of law. If somebody belongs to the Imam Ambali school or Imam Shafi, they will say, no, anything outside my imam, I will never do anything. I will not go out of that. But at this period of time, then they now came back to dispel all this dogmatism. Then the 5th phase is when it's modern period. This is modern period. This is the emerging era of the 21st century, which characterized by a new phase of globalization. At this particular stage, people now are talking about human rights. Do we have human rights in Islamic system? What is the position of women in Islam? In the area of divorce, talaq, and all these kind of things. So when other culture, they are looking at Islamic position on those issues from their own perspective. For example, in the Britain, so when you talk of a divorce, the talaq and khul, these issues, they are different doctrine as far as Islamic family law is concerned. But some scholars will now in the Western world look at it from the perspective of the Western knowledge. So we have a number of Muslim scholars on comparative law. I may not have time to discuss them in detail. We have Ibn Rushd, that the author of Bidaya al-Mujtahid and Nihaya al-Muqtasid. Then we have Al-Karafi, so who wrote separate book like Kitab al-Ahkam, and then you have Ibn Taymiyyah, Taqiyuddin, Abu Abbas, Ahmad bin Abdul Salam, Ibn Taymiyyah. So we know it's a collection of fatwa, and then there is another book that he authored, that is the At-Ta'arrud Al-Aql wa Al-Naql. So we have An-Nawawi, we have Muhammad Taqi Usmani, we have Ali Gomai. Then I want to be particular about Allama Ahmad Ibrahim. Allama Ibrahim is the one that first of all attempted a kind of a conventional comparative law in the form of Western system of comparative law. He was trying to look at Islamic law from the perspective of international law. So that marked the beginning of comparative law from Islamic culture, Islamic system to the conventional Western system. So, what is the position of Islamic comparative law in the 21st century? So, I try to look at the position of madhahib. So, despite the disagreement, despite what has happened in the course of history, every school are responding to arising issues. So, traditionally, they are concerned with weighing juristic opinion across Sunni and Shia school to identify strong proof, tarjih, or area of consensus, divergence, increasing engage with question of applicability, adaptability, and normativity in plural legal context. Modern comparative Islamic jurisprudence is shaped by transnational reality, such as Muslim minority context, state. We have the diaspora issue. For example, in the UK, you have a large number of Muslims. All of us are Muslim. We are here. We are here for good. We are here for good. The generation, the next generation of our children, they will be here for good. So they have to abide by the Islamic law. There's nothing anybody can do about it. Because that is the dynamic of Islam. Anywhere you find a Muslim aspire to abide by the laws of Allah. You cannot do anything against it. So, and that is why all the issues that are basically issues of law in the Western world, so we have to juxtapose it with Islamic law. And that is why there is argument among Orientalists or Oriental scholars about Engeres. Engeres is a kind of distorted term for English Islamic law. So, look at issue of Islamic family law. So there is argument about how are you going to resolve Islamic family law with British family law. So these are some challenges, and then the issue of human rights. So human rights is a very hot debate. So the scholars in Islam, they maintain that there is human right in Islam. But human rights, according to the Western, they are looking at it from their own perspective. And that is what you call the presentism. You are looking at human rights principle from the present situation. Even at the period of Islam, the emergence of Islam, the Islamic system was the best normative about human rights. Because before then, women have no right. Women have no right. So everybody, look at Allah. Allah used to talk about the act of Prophet Muhammad sallallahu alaihi wasallam in the Quran. Abasa wa tawalla an ja'ul ama. Allah say, and there are many issues like that. The Prophet was the head of state, the commander in chief. Then is under the Islamic law. So what are you talking about human rights? When the head of the system is under the law. And in an occasion, when a matter was brought to him, he told them, if my daughter Fatima violated the law, I will apply the law to her. Then what are you talking about, principle of human rights? Is it not the rule of law? But I want everybody to think about it now, whether we still have rule of law and what is going on at international level. Everybody can think about that. You can see the imperial Lord, the Lord of democracy, the Lord of human rights. You can judge that and look at Islamic system. Now, by conclusion, I look at some issues to conclude this particular volume. So, and that is the issue of trajectory of jurisprudence, religious or moral foundations, role of jurists and scholars, adaptation to changes, nature and authority of law, scope and applications, institutional structure, legal interpretation, and flexibility. I may not have time to go into detail. I try to look at how all these issues can be juxtaposed with the conventional system. You can see from that comparison, you can see the element of communality and element of divergence. Of course, that is the purpose of comparison anyway. It's not necessary to say a particular law is superior to another law. And of course, we used to say there is no law that is totally bad, but the people who implement the law. So you know why that comes to being announced. Fahkum bil adil. Adil is a critical principle in Islamic law. So to the point that anybody who is calling himself a judge, Allah say you must bear witness even against yourself, against your family. So I may not have time to look at all those issues that constitute comparative conclusion. Let's quickly go to volume 2. That is where we talk about methodologies of comparative law. When I talk of methodology as far as Islamic Islamic perspective is concerned, I'm not talking about, I said, when you say methodology in Islamic law, Quran is the source, Quran and Sunnah are the sources. Any other sources are considered as methodology when you talk of ijma, qiyas, urf. All these secondary sources, they came about by method of methodology. I hope this technology will not betray me. Okay, now let's move. Where is it? I am having an issue with technology. Okay. Oh, thank you very much. Okay. So first of all, when we talk about the theory of methodology, we look at the aims of comparative law from the Western perspective. You can seek to decode the password of the concealed cultural shadow. Because when you want to compare methodology, you have to initially when I started this study, what informed me initially was because I wrote on international law in the Muslim state, and I used Saudi Arabia as case study. So after that book, the idea came to me that why can't I do a kind of comparative study in Islamic law and Western legal system? When I started going to the library, reading book materials, I discovered that I cannot go to comparative system just like that. You have to understand the methodology. Otherwise, you just be beating about the bush. So what are the procedure that you must follow in order to do comparative studies? This is what took me to the ideal of methodology, the principle, and history. You have to read about history. You have to know the issue of a particular law. You have to know the custom, the culture. So before you can say, okay, I want to compare this particular law with another law. So the purpose is, okay. Contextual integration of law and culture. That is the purpose. Another purpose of comparative study. You have to contextualize the integration of law and culture, because law is an expression of a particular culture. And that is why you see Islamic law even recognize urf, the custom, as long as the particular custom does not contradict any text of the Quran or any text of the Sunnah. So a custom that is clean from contradicting the basic sources of Islamic law Islam allows uruf, and that is why uruf is one of the sources of Islamic law. Then, unification of law. When we say unification of law, we are not talking about uniformity of law. In arbitration, I remember when I was in Saudi Arabia, I worked with a lawyer. So when there is a conflict that have to be settled by arbitral rule, so you are now going to look at the law of the two regimes of law, the law of the party outside Islamic law and the law of Islamic law. How do we bring them together to agree on the particular issue? That is what we mean by unifications. So for example, when somebody wants to do a business from the Western world in Islamic state, and then this business has element of alcohol or any muharramat, what do? So you have to come to the table, you have to iron out the issue before you can come out with a final decision on those issues. Then experimentation of implementation of in legal writing. That is another purpose of comparison and methodology. Then broadening the horizon of legal education. So if you call yourself a student of law, your knowledge is limited only to the law applicable in your jurisdictions. You don't know what is going on in another jurisdiction. The world has changed from that positions, because as I said, the world now is a global village. If you don't know the applicable law in the other jurisdiction, you limited yourself to your own jurisdictions. You may find it very, very difficult to practice. So, and number 6, offering universal jurisdiction to International Court of Justice. That is why International Court of Justice, they recognize Islamic law. Of course, they don't have options, because when issue is involved in Muslim nations, they have to look at their interest. You have to cater for their interest. Although you see what happened recently when International Court of Justice came out with a decision of affecting a particular country or individual, the international decision of Court of Justice is jettisoned. Anyway, that is not, I'm not in politics anyway. Then tips of comparative law. So analysis and exploration, mutual influence among legal system, general theory of law, legal transplant, accommodation process, unification process, convergence of law, study in society and legal development. These are the theme of comparative law. Then, all these are explained clearly in the book. Then, comparative methodologies. So, first of all, before you talk about methodology, you have to talk about language skill. Anybody want to do comparison of a law, you must have language skill, because you have terms, legal terms, that when you look at those terms, they have many meanings. So you have maxims, maxim of law. So for example, name of that, no come abet. All these terms, they have meaning, and you have the same thing in Islamic law. So then cultural familiarity. You want to do comparative law, you have to be familiar with the culture of the jurisdiction you want to compare. If you are not familiar with their culture, you just model up things. Then all these are basic requirements. Then from functional method, structural method, constitutional methodology, historical methodology, macro level, micro level, tertium comparationis. All these are methodologies from confessional perspective. I will just look at one or two. We don't need to talk about language anymore. I've talked about that. Let us look at functional methodology as an example. When you talk of functional methodology, it's a methodology that's particular about function of a law, not theory, not all those things that about culture, structure, sources. The important thing about functional methodology is how the law will address the problem of the people. At the end of this particular presentation, I try to look at functional methodology, and I look at it from perspective of Maqasid al-Sharia. You know, Maqasid al-Sharia is the principle that where 5 values are preserved, and nafs, al-aql, and al-nazab, wal, al-mal, wa deen. That is life. Now, deen first, deen, that is faith, then life, and then lineage, akil, and property. Anyway, I'm very sorry I don't put them in order, but the important thing that we know that these 5 values are the aim of Sharia. It was, first of all, talked about by Sheikh Imam Ghazali and other contemporary scholars of that time. But when you look at them, I ask the question, can we juxtapose functional methodologies with Maqasid al-Sharia? This is a question. Then structural methodology is when you look at the element of a law, including institutions, sources of law, legal procedures, fundamental principle. So what about constitutional methodology? Constitutional methodology is when you talk of constitution is the ground norm, is the basic. When you talk of constitution is the light. And if you look at Muslim world, even Saudi Arabia has the constitutional law and talk about that Quran is the first sources of Islam of Saudi law. Because when you talk of constitution is the ground norm. Any law that any department or any agent of government or any parliament or any congress make, and the law contradicts the tendency, the tenet of constitutional basics, that law is null and void from the basic. I don't know whether I'm running against the time. Let me quickly check.
5 minutes.
5 minutes to go. Okay. Let me quickly go down therefore, because yes, I talk about tertium comparationis. This particular principle is a principle that puts 2 elements, two matters together, and they share the same characteristic. I then asked myself, can we put this particular principle against al-qiyas? Because in al-qiyas you must have al-asl, al-fara, al-illa, and al-ukum. Those are the 4 requirements of al-qiyas before you can apply the principle of qiyas. So the same thing, we have this tertium comparationis. I asked the question, can we put them together? Because nobody talk about that. Now let me quickly go to I have 5 minutes. Well, this is pre-modern methodology of comparative jurisprudence. We have tarjih, takhayyur, talfiq, taqlid, and attiba. All these are the pre-modern method of comparison in Islamic law. But the position now is, while we are retaining all this classical approach, we are still using some of the principle in the conventional law. Then I look at particularly taqlid and ittiba. And that is what I did towards the end of these presentations. Let me quickly go there. I said the parallel of taqlid in conventional judicial system is arguably stare decisis, that is binding precedent, a principle under which courts are obliged to follow legal precedents established by our court, even if they do not re-examine the reasoning. If Supreme Court make a decision, all the hierarchy of courts under that jurisdiction must apply the decision of the Supreme Court. But I ask the question, can we put taqlid together with stare decisis? That is a question. Then I look at ittiba. Ittiba has a parallel characteristic with persuasive precedence. Persuasive precedence in the conventional system is that when a court is taking the decision on particular issues, they are not bound to follow a particular precedent. Then they can look at a precedent, and that precedent persuade them to agree with decision taken in that particular issue, and then they adopt it. But the question is, when you talk of taqlid and ittiba, taqlid, if you go to the Qadi courts in many jurisdictions of Islam, no court in the Islamic system follow the precedent like in common law. Common law follow precedent. When a case decided in common law system, that decision of the court is a precedent. So when it's a precedent, when another case is before the court and the fact of that case is similar to the one that have been decided before, now the court will apply the decision of that case that as a precedent to judge that particular new court. But that is not the case in the Islamic system. A Qadi in Islamic court can decide a case without following any precedents. They base their decision on purely ijtihad, and that is also Ibn Taymiyyah. Ibn Taymiyyah campaigned among the scholars of his time and his student, Ibn Qayyim al-Jawziyah. They campaigned that every scholar must go to the original sources, Quran and Sunnah, and derive the law from there. And that maybe that is why the contemporary court of Islam, they are not using the precedent that is a taqlid and ittiba. But a taqlid and ittiba generally is when a scholar take a position as a follower, as a student of that scholar, I follow it and I say that is taqlid. The taqlid is when you copy a scholar without any questions. So the ittiba are the same thing. They are synonymous. Taqlid and ittiba are synonymous. So you can see that there are many areas that we can explore in this particular area of comparative law, and I believe, inshallah. But before I conclude, I want to say that I have the proposal that, inshallah, the volume 2, volume 3, and volume 4, volume 2 will follow specifically the history of law, Islamic law, common law, and civil law. I'm going to look at position of Professor John Makdisi. John Makdisi was arguing that Islamic law is the root of common law. It has generated a lot of argument, a lot of debate among scholars. Some people, some Western scholars said no. There's some scholars, they trace the history and they agree with Professor John Makdisi. And then when we come to the sources of Islam of law, particularly civil law, we want to look at the role of the scholars during the period of Emperor Julius. These jurists, they play a critical role in the civil law. That is why the idea of codification was introduced. Ironically, codification has been introduced into Islamic law as well. So, what are the interrelations between all these issues? And then when we come to the sources, Islamic sources, very, very interesting area. The Quran, the Sunnah, the Ijma. What kind of Ijma do we accept? Are we doing Ijma in the contemporary time? Do we have the meeting of the scholars? And that is why they draw a distinction between Ijma is Sarhi, while Ijma is Sukuti. Ijma that is very clear that scholars gather together and agree on issues, and then ijma is sukuti, when scholars take a position of issue, but they didn't talk about it. That is why you see many, particularly in my country, Nigeria now, you see the scholars, they are fighting on issues, although most of those issues are trivial, because they are secondary issues. So, brothers and sisters in Islam, I thank you very much for gracing this occasion. You can see that this particular area of comparative law, there is need for it. It's not a question of we are saying that we want to establish that Western law is superior to Islamic law, or Islamic law is superior to Western law. But the intention is to show their nuances and intricacies. When we do that, we leave individual to decide from himself or herself. Finally, I concluded by saying this book is about a comparative analysis of the historical trajectory, principle and methodology of civil law, Islamic law and common law, revealing both sharp contrasts and meaningful points of convergence. Civil law emphasizes codification and legislative supremacy. Common law prioritizes judicial precedent and incremental development, while Islamic law is grounded in defined sources and moral legal integration. Despite their differing foundations, all three systems aim to regulate social conduct, promote justice, and maintain legal certainty. Understanding their similarity and divergences not only deepen comparative legal scholarship, but Dawood Hamzah القائمة آتي إنك لا تخلف الميعاد. Thank you very much, brothers and sisters. You can see that because of time, I have been on my toe right from the beginning of this presentation. You can see that I didn't give myself time. I was talking without relaxation because I tried to see that I mentioned salient point. Now, Brother Ziad is now suggesting to me that maybe I consider coming back to this time. I don't know. We are going to put it together to see whether it is possible. Because people in the Western world, the issue is time, money. All these gentlemen and ladies that are here, if not because of their commitment, you hardly see many. I know many people online watching, but we put it together and see if it is possible. If it is possible, inshallah, you give out information from ICC. Now, finally, I was asked to talk about the difference between Sharia, common law, and civil law. I've talked about it, but Sharia is a law purely based on revelations. That is the issue of revelation and reason. Islam is Sharia is law of revelation and law of reason. Why Allah revealed the Quran to Prophet Muhammad sallallahu is the ground norm. Can you imagine a book that has remained for more than 1,400 years and remain relevant, remain applicable? That is why it is a ground norm of the Muslim law. But Islamic law is law of reason. Allah in many says, if you say, afala ta'akilun, afala tubsirun, afala yatafakkarun. Because when Allah talks, you have to look at law, you look at the law, the statement of Allah, and see how are you going to apply them. That is why you remember when Prophet Muhammad said this Sahaba to Yemen, Mu'adh ibn Jabal. He was asking Mu'adh ibn Jabal, when you get to Yemen, how do you judge the people there? He said, I will judge them according to the Quran. Allah said, and Prophet said, that's good. If you don't find solution in the Quran, what do? I will look at your Sunnah. The Prophet said, okay, supposing you don't find solution in the Sunnah, what do? He said, I will exercise my reason. Then Prophet put his hand on his calf and say, and thank Allah that has given the servant of Allah this so intelligence. So in other words, the Islamic law, Islamic Sharia is not just, Islamic law is not just law. If you look at the Quran is a compendium, a combination of many areas of human, many aspects of human life. You have science, you have history, you have philosophy, you have everything that you want to talk about. Look at people now that they are discovering the spaces. They are supporting their discovery from the Quran. It's the same thing, many things that are happening in many parts of the world that I may not have time to give you an example of them. So, Quran is not just a book of law, but is the source. Is the source that Muslims go to derive law. And they explain that as Islamic law in the light of the Sunnah of Prophet Muhammad sallallahu. And of course, when you say Sunnah comprises of hadith, the statement of the Prophet, then what he himself did, or what somebody said or did in his presence, that he approved it or disapproved it. Or even he didn't disapprove, he didn't approve, but keep silent. According to the scholar, even that one, that silence also is as well is a source. So this is the Sharia. I don't know whether I have answered that question. Then the common law is purely the common law. Let me start from civil law. Civil law also has religious elements. You see the Hammurabi law. I talk about the 12 slates in the Roman Empire. So this particular law was the most advanced law at that time that many people tried to copy. And that is why the issue of legal transplantation started even before colonialism. So legal transplantation is to transplant a particular legal system from one jurisdiction to another jurisdiction. That is what the practice at that time. Then later on, during the period of the regime of Emperor Justinian. So the scholars, I said, they did a lot of work, and their effort resulted into codification of the civil law. And of course, civil law is the bedrock of all the law in the Europe, the continental Europe, including even Britain. Later on, it was Henry II that introduced the common law in Britain. And of course, this is argument of Professor John Macdisi. So when Henry John II introduced the common law, I think in 12th century, so he introduced a number of principles. So they traced those principles, according to John Macdisi, to see that they have linkage with Islamic law. So I don't know whether I've explained this. It's a very complex history. I know that those people are hearing me, they will have a lot of issues to raise against me. That what are you talking about? Are you not talking rubbish? I'm talking from the limited knowledge I have. And that is why I want people to comment when they read this book, so that when I want to do the revision of this book, I will know how to incorporate those criticisms in the book. Inshallah. Thank you very much. So, I don't know. Yes.
Quickly, because of the time.
Yes.
And the common law.
Yes.
You define now the Sharia law.
Yes. Common law.
And the common law.
Common law is the law, is the collection of the law that operate in different jurisdictions in those days. And that is why I say it was King Henry II that introduced the common law. So it was during that period that he introduced the jura system, and then about 3 principles he introduced at that time, and they considered that introduction as a revolutionary step at that time. But essentially, it is law operating in different jurisdictions in Britain that were collected together to say it is now a common law, a law applicable in all the jurisdictions. Of course, they have religious elements, but essentially they are secular in nature. Of course, there was a case decided I cannot remember the date, where the court, it was argued in the House of Lords that British law cannot be divorced from Christianity. Secular something, that case. I remember that case. I used that case many years back. So, but essentially, if you look at history of common law, it has religious element. But as you know what happened when they separated the church from the government, that was the beginning of where the law is now becoming a secular system of law. I don't know whether I've tried to answer the questions. Jazakumullah. Now.
My question is related to
we are going to pray. We are going to pray. Sorry, madam. After the prayer, if you can wait and I can talk to you.